everyone, and welcome to today's webinar. We will be covering today effective business email compromise and ransomware mitigation with two professionals with extensive experience in these matters. We have Jonathan Fertlow, Managing Director in the cyber risk practice of Kroll, and James Wendres, Partner and Co-Chair of the Cybersecurity Data Protection and Privacy Practice at Snell and Wilmer. The session today includes 10 minutes for Q&A at the end with our two speakers, and you may submit your questions at any time using the chat function of the GoToWebinar platform, which should be available in your screen floating around on the right corner. With that, I'm going to kick it off to Jonathan to start the program.
Thanks, Leo. And I'd like to thank everyone for taking the time to join this particular webinar. We hope it will be useful and effective for you. Let's start with our first slide, Leo. Part of where we always like to start is, well, frankly, at the beginning. How do you prepare to be able to deal with some of the issues that can come up in the modern attack vectors such as business email and ransomware? It starts with a boring, simple, difficult task: data inventory, identifying what types of data you have and who has it in the organization. Part of the way we like to focus this is in a very straightforward way. Asking questions and identifying the places where and the types of data that you have ensures that you're going to have a data inventory. This inventory is useful in many ways, but probably the most important way is when there is an issue, when something has been accessed, when a system has been disabled or affected, you can know exactly what information was on it and whether or not that information triggers any legal, regulatory, or potential client-based requirements. If you don't know what you have, it's both difficult to protect it and extremely difficult to figure out how to respond to an issue with it. But it's easy for folks to say, build a data inventory. How do you do that? Well, the key is to have built-in verification points. Get it when a data inventory is created, make sure that there's a map, that the right policies are in place to enable you to be able to review and see the information. Also, what can be really critical is to make sure that what you're looking at matches up with the policies that you have in place, a data retention policy and a data use policy. And finally, after you've put in place the policies, gathered the data, make sure that it's being audited. Add to your audit function a review of data classification, data protection, and data retention. Check to see what people are keeping and where they're placing it. This is a tedious job, but when done right, it gives great clarity and protection and ensures that you, the board, and everyone involved in risk management can actually make decisions that are properly balanced. What are we keeping? What's the risk of keeping it? Next slide, please. Oh, one more back there. Now, after you figure out what types of data you have, you really have to ask who has it. What's really critical here is making sure that you're looking at all the different places that you're exchanging and sharing data with. Cloud services, marketing vendors, PCI services, web hosting providers. It means talking to both marketing and HR and looking at where they are taking and placing data. But in addition to tracking what you actually are sharing and who you're sharing it with, a really critical point is also ensuring that built into your processes, built into your contracts, are things like a contractual right to access and a duty to assist and a regular security review. I cannot tell you how often when a company has a data incident, it's because of a vendor, and because the contracts haven't been looked at in a long time, the vendor's concern about liability overweighs their long-term loyalty and ability or willingness to assist. Another very practical tip is to consider that in many cases where you're providing contractual structures that trigger on different types of levels, that the use of liquidated damages or other ways to ensure that people have to help in the event where they lose data to make sure that your vendors share, and help you when they lose your information. But again, how do you do that? Make sure you have appropriate review of vendor contracts, keep good copies of the contracts in a documented form, and include your review of third parties in your audit, in testing. And if you have a clause that allows for inspection, well, you really should make use of it. James, let me toss this over to you if you've got any additional input on this particular topic.
Yeah, thank you, Jonathan, very much. And two general points. One, as Jonathan was discussing the data inventory, we fully agree that it is, a very helpful exercise and tool to conduct in advance of any potential cyber incident. And it's important for everyone to understand that in some instances, that type of data inventory is actually legally required by law. And I'm particularly thinking about the General Data Protection Regulation. So anyone who is subject to the GDPR, has a legal obligation to create and maintain a data inventory that may be requested in the event of a cyber incident under that regulatory regime. On a more specific point, the contract review that Jonathan mentioned is extremely important because in the event of a ransomware attack, a business email compromise, any other type of cyber incident, there very well may be contractual obligations that your company has to notify its vendors, its counterparties, and it is much easier to assess those obligations during a data inventory rather than in the fog of war while you're attempting to recover from a ransomware attack. So we stress reviewing those third-party contracts as a critical part of preparation.
Thanks, James. I also want to make one last point in this topic area. Whatever you are doing yourself, you need to make sure you're asking your vendors to do as well. You can't have two separate standards. It can both significantly impact the effect of your security and create a difficult situation to explain later if that's part of the result of the issue. Leo, next slide, please. However, one of the things that we're seeing now is the rise of polymorphic ransomware fueled by malware that can alter and change itself. Now, the best defense against this type of attack is ensuring that you have a robust and well-structured data backup. This is straight from the 1980s, folks. This is the old school IT that has kind of dropped off as we become more used to cloud and shared capable backup systems. First, backup is boring. It's tedious. It consumes disk space and resources, and it can often sit for years without being needed. But when you need it, if it's not there, you have no other option. The reasons why backup fail, the reason why we are seeing people having to consider paying ransoms is because, well, one, in many cases, people aren't doing backup properly. They are either backing up the wrong information, not backing up what is important to the business, but what IT thinks is important. The media failed and no one actually checked it, or, which is very common, the attackers have turned off the backup processes. They are in the networks. They are zeroing out the network connected backup information, leaving you with no options. So part of what we want to stress in this common sense approach to some of the issues you're seeing is make sure that you're asking questions and demanding validation from your IT teams around the backups. We put a quick list of questions on the side there to help to kind of run through the question area. But when you ask these questions, make sure that you get not only an answer, but a validation, a check. Know the what, the where, and the how of your backups, and then test what you are told. If you have good backups, you can recover from a ransomware attack. Without them, you are faced with either significant loss of data and cost in recovery, or being put in the impossible choice of considering a payment to a criminal. Next slide. The other tool that can help you protect against the modern form of attack is multi-factor authentication. This is a industry term that really focuses on doing more than having a username and password for access, having some other thing that is in your possession, like a token or a phone that receives a code that has to be entered before access is granted. I cannot stress this enough. Username and password is simply no longer enough. There is too many data breaches that dump out credentials that make it possible to either identify and guess username and password or to simply look it up. So the key thing here, though, is that when you put in place multi-factor authentication, two things happen. Number one, the attacker who has username and credentials can't take the next step. They can't enter the code, which means they can't log on to the email system, no matter how successful their phishing email was. For social engineering, despite the fact that they've talked someone out of their password, they can't physically control the phone that has the code coming in. And for hacking, they might get into one system, but they lack the capability to move to multiples because they can't generate the MFA token. It is a tremendously effective tool that can allow for a significant security impact. And you know why most firms aren't using it? Because they perceive it as being something that slows the login or access process. The few seconds that are wasted will be more than made up in not having to sit through and deal with 3 to 4 months of data loss and data recovery issues in responding to a data breach or a data breach incident. Again, we put some questions on the side to help you identify the key places where you need to make sure that multi-factor is installed. It's not just for logging onto your computer. It should be installed for access to financial controls, audit reporting systems, ERP systems, access to email, and for any authenticated user access, VPNs, Citrix, VMware, FTPs, and for your administrators, it's critical that multi-factor authentication be used to ensure that any changes to domain controller require multi-factor access. Next slide, please. This goes back to, and part of the goal of the modern defense structure, which is assuming that you are going to be breached, building a defense that includes all of your users as the endpoints, the walls around your network. It means being able to identify the problem early. Now, in order to do that properly, you have to make sure that not only are you engaged in monitoring, which we're going to talk about in a bit, but that you've also set up a structure whereby the teams, the folks who are going to be your early warning system, know what an incident is and know when they should escalate it. Too often we see the definitions for an incident defined technically. There's a breach of a firewall. There's access to a server. There's loss of data from a database. But remember, we've talked about building a map of data and classifying it so that's critical and important. And that classification is not by what the data is, where it's located, what it is, what it does, and whether or not it has a regulatory, business, or personal impact. By simply changing your approach to a definition of an incident, ensuring that you're implementing your data classification into that definition, you can move what can be a difficult decision for a frontline person into an easy one. Rather than saying, if you see an access that creates a significant system risk, escalate, say, if you see access that exposes data that meets level 2 in our classification system, escalate. It's easier to define. It includes risk into the classification, and it allows folks to operate effectively. Again, to do this properly, you need to sit back and look at where you're getting notice about issues or incidents, ensure that they're getting trained in your incident response policy and that their input is included in the definition of an incident, and audit and verifying what's going on here. James, any input on this slide?
Yes, thank you, Jonathan. With respect to the types of data that should be flagged in the data mapping process and then used to help trigger internal notification steps and escalation steps, again, we fully agree with Jonathan's approach in his comments here. And just to provide a little bit of a specific example, one type of data that should certainly be at the core of this concept is personally identifiable information. And that term is tossed around a lot. It's discussed in the popular press, but it has a specific legal definition and a specific legal meaning. And in the United States, there are 50 different state data breach statutes, and then a handful of territories, U.S. territories, have their own definitions as well. But generally speaking, personally identifiable information is any individual's name plus some type of identifying information, government identification card, financial account information, anything along those lines. And so when you are conducting your data mapping and thinking through how your company is going to respond to a potential cyber incident, at a minimum, it is important to know exactly where data that you store that qualifies as personally identifiable information is housed. And so this would include information like employee records, employee health information, to the extent that your company has it, customer information. All those buckets of information are going to qualify very likely as PII. And if there's any unauthorized access and or acquisition to that data, there very well may be legal notification obligations for your company, both to the individuals affected and in some cases, state attorney generals or other regulators. So we would echo Jonathan's comments on the need to understand what type of data you are housing.
Thanks, James. Leo, next slide. Okay, so you've done the heavy lifting that we're asking. You've built a good data map. You know who has it, you know where it is. You've taken the time to make sure your contracts are supporting that, and you've even taken the time to make sure you have a good backup process. Now you need the next piece. You need to have visibility. You need to have the video cameras that allow you to know when the bad guy is in your network. And that's called endpoint threat detection. Why use of the word endpoint, by the way? Well, it's based off a concept that you're going to hear about of zero trust security. We're no longer in a world where all your data stays behind a nice firewall in your network in your office building. Your data is being accessed by your staff, by your key decision makers on their mobile devices, on their laptops, and they're using the common infrastructure of the cloud and the internet to get access to your data. So it means that each and every one of those individuals is in fact an endpoint. They are the wall of your network and they need to be protected. The best way to do this is to use the next generation tool sets that are called endpoint threat detection tools. There are many of them out there, and the goal is very simple. They identify and flag bad executables, similar to antivirus, but more effective because they're not just basing it off a pattern match, they're looking at what the executables do. And that means they have the capability to analyze behavior shown on a computer against attack patterns and methods. Think of it like how a department store detects theft. They've learned where people go to steal. They've learned the places and ways that people use to hide things that they want to bring in to take out, and they look for those things. A good endpoint threat program identifies, analyzes, but also uses information from other sources to add to its knowledge. And it gives you the capability with a good team member to threat hunt, meaning to look for things that might be indications of an attacker being in the system and trying to learn their way around. Finally, the key part is when you do all this, when you get this visibility, you have to have a way to rapidly notify the team to act on a validated threat. This is the concept behind endpoint threat detection, this concept of total network visibility, and it is the way in which you get security in a world of highly mobile, highly editable attack vectors. Next slide. But you need to also make sure that you're preparing for an issue, for a problem. Golden rule. I've been working these since the year 2000. Over 140 while I was a prosecutor and over 700 since I've been at Kroll. It's never the breach that kills you. What it is how you respond. And while you can do an awful lot yourself to build out and to make sure that you're prepared and ready, there are times when these incidents require help quickly. You need to have that help lined up. You don't want to be negotiating with the fire department when your house is on fire. You want to know that you trust your communications firm and you like the way they communicate before you need a critical message out to your customers. You need to make sure that you have comfort and trust in the advice and approach of your firm that's helping you with legal matters before you start to ask for that advice. And you need to make sure that your technical teams and your systems are known and comfortable and your approach is structured with your incident response firm so that they're not learning as they walk in the door trying to help you. All of this means making sure that you're taking the steps to line up the help that you need and making sure that you're putting in place the legal structures that it's easy to draw them and you're ready to roll. James, any comment on this slide?
Yeah, just quickly, we found that it is very helpful for our clients to establish relationships with law enforcement and in particular the FBI as part of this development of relationships. And a couple ways to go about doing that. One is, and I would encourage everyone on the phone, if your company isn't already, strongly consider joining InfraGard, which is a program that the FBI runs in your city and will bring together private industry, the FBI, academics, and is a very helpful forum for sharing threat information and developing relationships with law enforcement. And the other way to go about it is simply to reach out to your local FBI field office cyber division, introduce yourself and the company. And the reason to do all this is, again, you don't want to be meeting the FBI for the very first time when, as Jonathan said, the house is burning down. They'll often be critical decisions about whether or not to voluntarily cooperate with the FBI, whether or not to invite FBI hunt teams into your premises, and having a relationship and understanding who you are going to be dealing with will help make those decisions easier ones to confront.
Excellent points, James. Next slide, Leo. And all of this means that in addition to the preparation, you need to think about how you're going to respond. And that means, have you built an incident response plan? But you know what? It's easy to download one of those from the internet and just drop it on the desk and say you have it, to check the box in the compliance checklist. But does your incident response define what an incident is? Has that been discussed with the people who would need to make that decision? Does the team have decision-making authority? How often is the criteria that you are using to define escalation and incident reviewed? How often do you test this thing? Is it just a dusty document sitting on the desk, or is it an active part of how your team works with this? Let me give you one practical example. A good incident response plan doesn't just say who to escalate it to. It talks about how to communicate to your team, to your business, to ensure that your staff don't flow onto social media, adding to the confusion, fear, and doubt in an attack, and saying or stating things that can have legal repercussions. They know that in the event of an incident, that they're not to communicate that way. An incident response plan is much more than an escalation list. It is a training guide for an entire firm in dealing with a digital crisis. And it's critical to ensure that it's being properly run. And the way you evaluate one is very simple. Based on an incident response, does it define what we're to do? Does it outline what technical solutions and expertise are needed? And can everyone in the organization understand what they're supposed to do in the event of a data breach incident? And they could be affected. If not, if it's not a clear read, if it's not something being actively used, you need to update it and implement it as part of your business continuity and business response training. Next slide. I think there's one more back there, Leah. So the last part is if you do have an incident response plan, you should also have an incident response team. Make sure that key people are on it. We've given you a quick list of some of the people to look at, but most importantly, look at who's leading the team. Are they competent? Are they familiar with the incident response plan, and do they have decision-making authority? And have we made sure that our security and incident response team is appropriately defined to cover the real risks to our business, not everything that has the word security on it? And finally, are we properly supporting them? Are we providing training? Does the team have access in the event of an incident to all data, all groups, all silos? And does our IR team look at our vendor security to ensure that they know who's keeping our data and who they need to ask for if information was needed in order to evaluate a response? These are all questions that allow you to ensure that the steps you're taking to protect your business and to protect your clients are ready to roll in the event of an incident. Remember, it's not the breach that kills you, it's how you respond. And how you respond is determined by your willingness to spend the time to ensure that you've laid the groundwork to be effective when a breach comes. We all grew up doing fire drills, so we all know how to deal with a fire. If you don't train, if you don't plan, then when you do experience a data incident, the breach will kill you. And with that, and what happens when you have a significant incident, let me turn it over to my friend and co-presenter here, James. James?
Thank you, Jonathan. And we're going to pivot now to the world that will exist in the immediate aftermath and in the days, weeks, and months that follow, whether it be a business email compromise attack, a ransomware attack, or any other type of cyber incident in which your company and its incident response team is going to be responding to that crisis. And the first thing to understand that that is really going to be at the center of my comments is that there is very likely going to be litigation or regulatory inquiry or regulatory enforcement. And the general bright line rule is that in litigation, in regulatory enforcement matters, there is an obligation to provide all information. And so the Supreme Court in the United States, Brian, has made this point going back nearly 70 years. But the rule of general obligation to disclose is much older than that. It's an ancient rule, but it now is being applied in very modern times and in the context of very modern threats that you all are facing. And so the key takeaway here is that you should assume that you're going to be required to disclose communications or reports unless a particular exception applies. And therefore, in conducting incident response, you should treat everything, all records, all communications, as potentially subject to disclosure. Leo, next slide, please. In thinking about the word everything, let's understand exactly what type of information and what type of records are going to be created during an incident response effort. The types of information that you will see and that will be generated are going to include assessment of your network's vulnerabilities, potentially real-time suggestions from either your own IT team or your third-party forensic provider about improvements that can be made to your cyber security posture. There very well may be discussions and communications about previous similar incidents and how they may be or may not be related to the current incident. Potentially management or the board's knowledge about previous incidents and what was done with that knowledge. potentially consumer complaints, potentially information that may be used by adverse parties down the road as some demonstration of alleged negligence. And then, there may be incidents that occurred previously that the company either did not know about or knew about and chose not to provide notifications about. And so all of that information is going to be critical to helping you and your IT teams clear the fog of war, gain a clear-eyed understanding of what occurred, why it occurred, and what steps need to be taken to regain your footing and regain your normal business operations. But that information is also going to be very valuable to any adverse parties, in the litigation or regulatory matters that are to come. Leo, next slide. And so the goal here is to minimize your disclosure risk in responding to a cyber incident. As I mentioned, there are, lawyers who very well may be interested in the type of information that's generated during incident response. Regulators may very well be interested in information generated during incident response, but so may be the press. Any one of us who picks up a newspaper or reads one on our phone, sees headlines commonly about data breaches or cyber attacks on companies in every industry and in every sector across the country. And so this information very well may be sought out by our press. Leo, next slide. To give you just a flavor here in a few minutes of the types of regulators or the types of adverse parties who may be interested in seeking information about the cyber attack and the response to that cyber attack through discovery or otherwise, we have listed here on the slide five different categories. First of all, the Federal Trade Commission has taken a very active role at the federal level in pursuing what it views as cybersecurity lapses. State attorney generals, again, drawing on my comments previously, there are state data breach laws in every one of our 50 states and our territories, and those state attorney generals, or in some states, consumer protection agencies, have taken the lead in investigating and sanctioning firms who sustain cybersecurity lapses that result in unauthorized access to personally identifiable information. If you're a public company, the SEC will certainly be very interested. Your shareholders may be very interested in understanding what steps were taken, not just during the incident response, but preceding any type of incident response in terms of your preparedness. Business partners, this draws on our comments earlier about the need to understand what your contractual obligations are to vendors and other third parties that you have contractual relationships with. And then you very well may have private plaintiffs who seek remedies against your company. This can include, but is not limited to, classes of affected individuals whose information may have been exposed in a cyber attack. And Jonathan, interested in your perspective on some practical experience with these types of discovery requests.
Absolutely, James. Kroll does a lot of these investigations, and we've actually built into our contracts a clause that often confuses people. We require subpoena indemnity. Why? Because in data breach incident issues where it becomes identified that Kroll's conducted the investigation, we routinely get a subpoena around the side of the case directly to us, looking for all information we've supplied to the parties. And the retention of counsel and bringing our client and their counsel back into the engagement can often be a significant expense and structure. So the privilege argument will be tested on both ends. It's an absolutely common, almost regular aspect of our working cases for clients. prior to us testifying for them. Back to you, James.
Great. Thanks, Jonathan. And Leo, next slide. So we've identified the problem, the generation of information during incident response work, that may create problems for your company from a litigation or regulatory standpoint. Let's give you the solution. And the solution is, as I said at the beginning of my remarks, to rely on an ancient rule, but to apply it in this modern vector. And the rule to rely on, make sure you understand and implement effectively, is the attorney-client privilege and the attorney work product doctrine. There is no federal or state standalone privilege for cybersecurity communications. So because of that, we need to fall back on these two types of protections. And again, the goal here is to keep information generated in incident response within these protected categories. Leo, next slide, please. The attorney-client privilege is the strongest form of protection, and with two exceptions that I'm not going to discuss here, it provides full protection of communications between attorneys and their clients when the communications concern legal advice. Critically, that protection also applies to non-lawyers who are assisting the attorney or the law firm in representing the client. And to make that concrete here, that protection applies to third-party forensic providers like Kroll, who are assisting a client with incident response, so long as the engagement is structured in the right way and the engagement is conducted in the right way. And what that means is that the third-party forensic firm be retained by the law firm on behalf of the client. And it's very helpful to include language in the statement of work or in the engagement letter itself that makes clear that the third-party forensic firm is being retained to assist the law firm in providing advice in anticipation of litigation or regulatory proceedings. Leo, next slide. This slide touches on the requirements for the work product doctrine. It is a slightly weaker form of protection and generally is subsumed within the attorney-client privilege. So I want to make everyone aware of it, but Leo, we can move to the next slide. This concept of the attorney-client privilege being applied in incident response matters, at this point has been litigated heavily and repeatedly in federal and state courts. This Genesco v. Visa case is just an illustrative case, but in this instance, the plaintiff sought information about the incident response effort that was conducted, but the court held that incident response information was properly protected by the attorney-client privilege and held that it was not discoverable. And important to the court's analysis, consistent with what I just mentioned, was that the agreement involving the forensic firm provided that the engagement was conducted in anticipation of potential litigation and or legal or regulatory proceedings. So it's important to make sure that the engagement is structured correctly at the outset. It is important also, Leo, next slide. It is also important to make sure that once you have structured the engagement appropriately, and we're going to talk about the conduct of the engagement in just a moment to finish up about how you ensure that protection stays intact. But it's important to recognize that once you've protected those communications, you need to be very careful and thoughtful about whether or not you use any information developed by your incident response team affirmatively. And the reason to be very careful and thoughtful about that is because if you do, you very well may be found to have effectively waived the privilege, and that is what occurred in this Leibovitz versus United Shore Financial Services case, in which the court made the point that the attorney-client privilege in incident response scenarios can't be used as both a sword and a shield. In this case, United Shore disclosed the conclusions from its forensic firm's reports, but claimed that the work product protection still applied, and the court found otherwise. So be very careful once you've gone to the effort to protect the privilege that you don't waive it without thinking that decision through very quickly. And Leo, next slide. The takeaways here, practically speaking, are if you are in the circumstance where you are responding to a cyber attack, it is going to be to your benefit to add outside counsel who have been retained specifically to assist with that incident response, again, in anticipation of litigation, to ensure that they are included on all internal, external correspondence. Consider having all correspondence among your IT team directed to outside counsel. Certainly the entire IT team needs to be included on the communication, but it can be a very helpful practice in litigation down the road for email messages in dispute to be directed to the outside firm. A absolute must is that all email correspondence, all records and reports generated as part of the incident response are marked with the attorney-client privilege header, the attorney work product header. Leo, next page. Coming back to the point I made earlier, very helpful to have your law firm retain your third-party forensic provider, someone like Kroll, to conduct the incident response so that contractual structure is set up in advance. And then the last 2 points, these go to the implicit waiver. Make sure that you are very careful about who you share information with, because if you share it outside of your law firm, your incident response firm, you very well may lose the confidentiality element that's required for the attorney-client privilege. And for that same reason, limit the number of employees internally who that information is being shared with, again, as a way to control that protected information and make sure that it is not being waived implicitly. And with that, I will conclude my comments, and I think we have a few minutes here for questions.
Yeah, thank you, Jonathan, and thank you, James. Great points you made. I have received, I think they sent it just to me, not to the entire chat, but I have 3 questions, and I wonder if we can start. But before we get to the questions, I want to just invite everyone to submit any additional questions or comments via the chat function that's present in the GoToWebinar platform. So I think the first question will be great for both presenters. It was around ransomware payment. Clearly, it's a business decision, but the guest is asking, if we decide to make the payment, what are the steps we need to take to help secure and prevent any potential downfall?
So James, why don't we split that? I'll touch on the technical side. You can handle some of the legal implications.
Great.
So first, when you're dealing with a ransomware payment, is you need to make sure that the person can actually decrypt the data. Keep in mind that it's important to look at the data that's encrypted to see if the encryption was actually successful. Corrupt data won't be decrypted no matter how much you pay, nor will small files. So small things that can't fully gain encryption don't get recovered. They've just been corrupted and destroyed. This is particularly around things like images on websites. Those small little GIFs that are used to identify things can be functionally destroyed by a ransomware assault. The second thing is to make sure that anything that's being used to decrypt is tested, and then the decryption keys pulled from it so that tools not provided by a criminal are used in order to decrypt the information. The final piece is to understand that when you make that payment, you have identified yourself as a mark. These folks are not going to go away, they're going to continue. You will need to engage in significant remediation efforts to ensure that they don't come back again. James?
Thanks, Jonathan. The other thing to understand, and this may be an obvious point, but the perpetrators of the ransomware attack are criminals by definition. And so you will be making a payment to not just a criminal, but in almost all circumstances, a criminal organization. With that in mind, the FBI has taken the position publicly that it will neither weigh in sort of favorably or unfavorably on a company's decision to make a ransom payment, but has said specifically that it understands that those decisions are driven by business considerations. And so there is, from the FBI's public guidance, no sort of public discouragement of making those payments. Having said that, what we have found is that it is very helpful to engage with the FBI in the event of a ransomware attack. In some instances, the FBI will be able to provide information that it has about the perpetrators of the attack. The FBI has, a very broad aperture that may be helpful in touching on some of the items that Jonathan mentioned, including ensuring that this particular group will provide the decryption key, among other things. It is also helpful, though, to keep law enforcement apprised of the company's decisions about whether or not to pay the ransom, and to memorialize that internally in the event that there is ever any second guessing or Monday morning quarterbacking of the decision to pay the ransom. That would be my primary advice.
Great. Thank you both. One other question that came in right now was, what would the role of a privacy officer typically be in data breach response?
Again, I think that can be a good split answer. Technically, well, one area that becomes very critical during a incident response is there's the collection of information from multiple places in order to conduct an investigation. And sometimes during the rush of an investigation, there can be movement of data that by its nature could create other issues. And while there tends to be an implicit exception for the capability to investigate, it's always a good idea to have a good privacy officer who can help identify potential areas of conflict and work with the team in order to provide solutions around data localization and other placement of information for investigative purposes. That being said, showing that that person is working with the team, even if there needs to be for an investigative purpose a transfer of data in a way that might not fit within a regulatory environment, it at least helps with that structure. Let me pass it over to James for further insight.
Yeah, thank you very much, Jonathan. And I don't have a whole lot to add other than, to the extent that your company has a data protection officer, that person should certainly be a part of the incident response team. And again, as with the data mapping or the data inventory discussion that we had earlier, if you are a company subject to the General Data Protection Regulation, GDPR, the European data protection regime, you may be required to have a data protection officer. And in those instances, there are specific affirmative obligations that that individual takes on in ensuring the company's cyber preparedness and compliance with the GDPR. But as Jonathan said, a data protection officer should be the person in your organization with as much, if not more, insight into the type of data that is being housed, what it's being used for, who it's being shared with, and will be critical to informing incident response strategy at all stages of that effort.
Great. I know we're over a few minutes, but we have one last question that I thought was really interesting. It was around cyber insurance and incident response retainers. Would there be a better option, or should companies pursue a combination of both? What would you recommend?
So I'll go first on this. The advantage of a retainer is that it holds a place in the line for you, particularly in the event of a widespread data breach where multiple entities are impacted. But in many cases, particularly with companies like Kroll, the retainer is not just used break glass in the event of fire concept. It can be used for other things that are part of your overall good cyber health: assessments, evaluations, assistance with data mapping, penetration testing, other things. So a retainer can be a great way to stage and to budget for long-term cyber issues, while also making sure that you get the value of cyber insurance should you need it. But cyber insurance, to me, particularly in large-scale data issues, is a critical component to your risk management strategy, because it helps you mitigate broader risk, but it also allows you to understand the cost and where you are going to accept risk, because you've got additional backstop to be able to validate that going forward. James?
Yeah, and I think this is the perfect question maybe to wrap up on, because my short answer is I don't view that question, or the answer to the question, as an either-or proposition. I think, as Jonathan alluded to, optimally you would have both. And the thought being that on the front end, on the preparedness end, you would have outside counsel, forensic provider like Kroll, with a retainer, but not just standing by, working with your company and your team to take the preparedness steps that we've talked about to mitigate the downside risk on the other side of a ransomware attack, business email compromise, et cetera. But if and when you are on that other side and are in the throes of responding to a cyber incident, as Jonathan said, having cyber insurance in place will help mitigate that downside risk, because these are not necessarily inexpensive matters to deal with, and so I would recommend pursuing both goals simultaneously.
Excellent. We do have a few additional questions. We may answer those via email, but before we wrap up, I think we have a quick yes or no answer for a question that triggers a yes or no answer. Someone's asking if either of you are aware of cases where insurance carriers have had good success in subrogating against a web hosting provider or cloud provider for a breach or electronic vandalism event.
I'll answer first. Very good question. Pretty specific one. I do not know of any instance where that has occurred. Although that's not to say that it hasn't. I just haven't run across that in my practice.
About the only thing that I have seen that is like that is the use in botnet cases by Microsoft in order to ensure that folks complied. The threat of litigation was used in order to get the exchange of information, but I'm unaware of anyone systematically going up or downstream on cyber breach issues on the collection side. But I'd also caution that we're still pretty early in the litigation cycle around the widespread use of cyber insurance. I just don't think we know yet how that's going to play out.
Excellent. We will wrap up here. Thank you both for answering our questions and for the great session. If your question hasn't been answered, we'll try and reply via email. But thank you all for participating as well. And stay tuned for the next webinar.
Thanks, everybody.
Thank you very much, everyone.